Hello dear friends and followers, welcome back to my channel. Today we will learn about a most important topic, that is basic structure doctrine, which was propounded by Justice Hansraj Khanna. It is a principle which says law is valid only if it is in accordance with the basic feature of the Constitution. As we know, legislature makes the law, executive enforces it, and judiciary has a power to interpret laws. All are independent in their jurisdiction, but whether legislature has absolute power to form laws or whether legislature can amend fundamental rights. So let us answer these questions in this session. Before understanding basic structure doctrine, it is important to know about Article 13 and Article 368 of the Constitution, because as both are in conflict with each other. Article 13 of the Constitution talks about what is law in the negative sense. According to this, the state shall not make any law or action which is a violation, abridgment or contravention in anything contained in Part 3 of the Constitution, that are fundamental rights. Article 368 in Part 20 of the Constitution talks about amending power of the Parliament. It grants power to make amendments and empowers Parliament to amend the Constitution by the way of addition, variation or repeal any provisions according to the procedure laid down. If we closely look into these articles, they are both in conflict with each other. In 1951, Nehru's government passed First Constitutional Amendment Act 1951, in which Article 31A, 31B and 9th Schedule were added. It states no law or amendment shall be held as null and void if it infringes Article 14, 19 and 31, which are fundamental rights. Soon after this amendment was passed, in the case of Shankari Prasad versus Union of India, 1951, First Constitutional Amendment was challenged. Supreme Court held that Parliament can amend any part of the Constitution, including fundamental rights, and Article 31A, 31B and 9th Schedule is legally acceptable and valid. Again, in Sajjan Singh versus State of Rajasthan, 1964, Supreme Court upheld the decision of Shankari Prasad judgment, which states under Article 368, Parliament can amend any part of the Constitution. In Gokalnath versus State of Punjab, 1967, Supreme Court revised its decision and held that Parliament under Article 368 could not amend fundamental rights, and this power would only with Constitutional Assembly. Then former PM Indira Gandhi's government enacted various amendments to the Constitution such as 24th, 25th, 26th and 29th. All four amendments were challenged in the Keshwanand Bharati case 1973, where Supreme Court headed by 13 bench ruled that Parliament could amend any part of the Constitution so long it does not alter or amend basic structure of the Constitution. This case saved the democracy because it restricted the power of legislature under Article 368. In this case, basic structure doctrine was introduced. However, the court does not define basic structure doctrine but listed some of the basic structure of the Constitution such as democracy, secularism, separation of power, supremacy of the Constitution, federal structure and individual freedom. The conclusion is that basic structure doctrine prevents the unlimited power of the Parliament. Laws are tested on the basis of basic structure of the Constitution. Legislature can amend fundamental rights by constitutional amendment without infringing basic structure of the Constitution. Thanks for watching. Meet you in the next video. Until take care. Bye bye.